That specialist is the appeals, GST appellate also. This is,
These are all GST appellate authorities matters? Yes, so we have already taken a view. So we are disposing of it. No, that's why we took the matter.
done this,
And matters are like this.
Yes, now the filing is till 30th June. All
Sir, we will follow this.
Yes.
Item number 6, your occupant, in case of refund, your occupant not requirement.
only change in the WPC number 10,094 2025. So Lordship may kindly look into 10,094 2025.
What is that?
Your Lordship, here your Lordship, the order dated 1st May. Your Lordship, it is a case of refund rejection. So since appellate tribunal is not there, your Lordship has admitted. So since appellate tribunal, let him file appeal. Only difference is that he is not required to deposit the fee deposit.
That you will see.
That you will see. There is no difficulty. Go
Only
there.
that.
Go there.
That would reverse order will remain.
Your Lordship.
Yes, yes.
Same order.
Yes, go. Man. Anything left? On this account, anything is left?
No. Your Lordship, some of the new matters I have given.
No matter, forget about it. Anything old matter where we have kept it on that ground
No.
is left. All are disposed of.
All are listed today in special list.
No, Your Lordship, some of the matters are there.
You give them.
Give the number. Why are you not giving the number?
Since long we have been asking you, you are not giving that way. We instructed to list this, whatever little we had from the registry.
Please give the number. Anybody who is there, tribunal matter, please give.
Weekly list. Item number 1.
Once they petition the court. Not comply.
Regarding compliance of the order.
I just wanted to.
I have a submission with respect to compliance of the order.
Now tell me first the operative portion of the order. You just show us what page.
Page 9.
Page
9 or this person. 5/10/2023. Page 9 for the affected 5/10/2023.
Now it says that Bindusagar Samantarai case, it will be. Where is the Bindusagar Samantarai?
That I have submitted in the last part of the.
Rehabilitation assistance. Rehabilitation assistance.
No, that's true. It's a compassionate appointment that has to be done. So what is the ultimate direction?
The first title of that judgment runs for 39 pages. So I have given only 2 pages only to avoid that.
Your application was within 1 year from the date of the death.
Yes.
Have you formed the special committee?
But he has already been given appointment in 2015 and his service has been regularized in 2022.
Then what remained?
No, the direction was that, and the notification of the government that those who possess qualification for group C appointment, their case will be considered. I was the BSc Computer Science.
Sir, whatever be the direction is very, very categorical. It says special committee to be constituted and you should be given an appointment under the rehabilitation scheme. If they have given you an appointment, if your appointment appears to you is not in terms of the rehabilitation scheme, that's a fresh cause of action. That is what is to be done. how the complaint,
That is-
it is only related to appointment.
Right.
Now appointment has to be done, whether at a group D, group C or what. It is a fresh consideration. We are concerned with the appointment. Appointment
That
has,
is before the writ petition.
sorry.
That is, your lordship may kindly
This is
consider.
what
May I-
is,
may I-
brother,
That is
it
before
says
the writ
that the
petition.
state will form a service.
I'm something like that. Before the writ petition, I was
Yeah,
given group
appointment
D
order
appointment.
and the regularization order, both are there.
Before filing of the writ petition, I was given group D appointment. That is what.
Sir, your prayer was cause the notification dated 3/8/2015 under Annexure 3 containing the recommendation of the meeting under Annexure 4
Right.
and issue direction to the opposite party to consider his case for appointment against the post of Group C
Yes, your
category
lordship.
from the date of joining all services. Now,
I
this
have
was
been,
Yes. The court disposed of the matter, saying that Mr. Mishro, the learned advocate for the petitioner, you state that the case is covered by a judgment of this court in Bindusagar Samantarayan, to which the government advocate also raised no objection.
yes, your lordship.
So the court says, in view of the matter, this writ petition stands disposed of in terms of the order of the Bindusagar.
Yes.
Now, this Bindusagar, the only thing is say we direct the appellants to consider the case of the petitioner respondent within a period of 4 months. For that, the state shall form a special committee for consideration of cases of the writ petitioners in order to assist the authorities to issue the rehabilitation or appointments. It does not say at what post,
Yes, sir.
appointments. We make it further clear that this court will not extend the stipulated time, keeping in view of the state government shall expedite the process of the formation of the committee. The cases of rehabilitation appointments are to be considered with empathy, and hence the rigid technicalities are not germane. Before parting with the record, we direct the respondent to extend all cooperation to the state government. So if your case is disposed of on your submission in view of this judgment, this is what the operative portion of the judgment.
Yes, sir.
It does not talk about that you should be given a group C or a group D or a group A or a group B. You yourself abandon this prayer.
No.
You say that I am covered by this. So whatever the direction is passed has to be followed.
Yes.
If they have given you an appointment, maybe it would be, that's a fresh cause of action, that's a fresh cause of action.
No,
You
they
can
have-
go and say that this appointment scheme does not talk about the group D appointments, but the eligibility, educational qualification has to be considered.
May I submit my only one submission? Before filing of the writ, your lordship itself, I was given group D appointment.
Sir, what is the law? You may have prayed 15 relief, you may have claimed 15 reliefs.
Yes, sir.
If the court has granted only one relief, does it not tantamount to refusal of the other 13 reliefs?
Yes, your lordship.
So
If-
you may have claimed group C. Court says, no, I am not going into, I will go with this judgment, which does not talk about any kind of a C category, group D, group C, group B, group A. No.
I am submitting the lordship. What has happened? I was given group D appointment. That I challenged before your lordship that 1990 rule says as per the qualification the appointment is to.
But why you argue this? Don't you have, if you have so much of resentment, why you did not argue this point that this point is not a simpliciter point covered under the Bindusagar?
Bindusagar case, your lordship exactly said that. Bindusagar case.
Sir, the operative portion of the order I read,
Yes, your lordship.
if I am not wrong, what does it say?
My lord, I am submitting, your lordship. Your lordship may only permit me to submit. Number of persons were given group D appointment. Now, this was challenged because the commissioner cum secretary passed a notification that all the appointment will be given in group D. That was challenged, your lordship. My lord directed that those who possess qualification prior to 2020 they will be, their case will be considered against group C and there is a notification by the
Sir,
group.
I do not find from the operative
That-
portion
that
of the
your-
order which you are talking about.
Now, Your Lordship, if the committee considers it, I have no objection. That has not been done.
Sir, I do not think so. The committee,
Yes,
the
yes, my
committee,
lord. Yes.
the special
That's the wrong
committee,
thing is saying. Committee has never considered.
is what consider?
Your Lordship may kindly say Annexure 7, page 26. Committee has never considered my case.
Lordship, my
Annexure 7, page 26 of the counter. That will clarify everything, ma'am. Only one notification of the government after number of litigations.
Lordship,
Okay,
kindly see.
Annexure
Para 3
7,
of the
page
Bindu
26.
Sagar judgment. Para 3 of the Bindu Sagar.
No, that is
What
true.
was the case of Bindu Sagar? Lordship, may kindly see. That is a case where the petitioners had approached this honorable court saying that our cases should have been considered under the
Old rules.
old rules, not under the new rules.
True.
That is the case.
And this the court has said under the old rules.
Yeah.
Court said under the old rules.
That's all.
And in the meantime also, in Jita Luha case, the Supreme Court has also said that in view of the new amendment which has come into force, all the cases where the applications have been filed prior to commencement of the 2020 rule, they are to be considered under the 1990 rules. Case of the petitioner is that he was given appointment under the 1990 rules, but in a class 4 post. So he said, no, I should have been considered against a group C post instead of a group D post.
But
That is exactly what they have done with respect to others.
Pick out a third case which is not
This contempt application is.
Your Lordship may kindly
This contempt
permit me to
application is taken out by the petitioner.
Annexure 7, page 26.
Petitioner and as alleging that the
Date of death of government employees prior to
Yes,
commencement of.
whatever be the reason, we will go in a contempt. You have the another avenues.
Item number
May
2.
kindly permit Annexure 7, I may file a press writ petition.
Sorry, I will not. That's your right. You take care of that.
Once your lordship is disposing of, I am helpless, my lord.
This is the contempt is dropped. I am simply that it does not amount to contemptuous
Your
act.
lordship may only permit Annexure 7, page 26.
No, sir.
There is a direction by the government that it will be reconsidered.
We have already dictated the
Your
judge.
lordship may permit me to file a press
No,
writ
that
on
is
Annexure 7.
what is it? If you have a statutory constitutional right, you invoke. Why a leave of the court is required? I am from the day one, I am against these principles. Seeking a leave of the court. If you have a statutory right to move, you have a constitutional right to move. Who can prevent you from moving? Can a court say that you can't assert your constitutional right?
Only situated persons were given.
Whatever the remedies available.
Once this matter.
In the contempt order is only restricted whether it is a contemptuous act or not. We are not entering into a merit of it.
Only one.
I was cautious when I was dictating this judgment.
I
have not.
Only one line.
No, sir.
This matter went to Supreme Court wherein it was confirmed.
Whatever.
Now, Annexure 7, the government has passed that those appointments under Group D will be reconsidered. Then I am.
It is up to them, whatever they want. We are concerned with the operative portion. That's why I quoted. We quoted both the orders.
No, it's got.
What happened? What was the order in your petition? And what is the operative portion of the order in Bindu Sagar Samatra? That's all.
Your lordship may permit on 13 June 2025 notification. My case may be reconsidered. I may.
You are a seasoned lawyer. Once the court dictates the order, I think a responsible member of the bar knows the restraint to some extent. Please consider. The juniors will understand.
Similarly situated persons will get.
I do not know that if it is there, we are in a contempt. That's all. We are not going into the writ. Had it been a writ petition, we could have gone into. Contempt is never used as an original proceedings.
Yes, your lordship.
That's all. We are concerned with the violation.
Item number
Your
2.
lordship may debar me from filing a fresh writ petition.
If you are understanding of law, then it is my misfortune, sir.
Because 13th June 2025.
I can't say.
Permits reconsideration. Only your lordship, one line observation.
Yes.
Saved me. That only one line observation, my lord. 13th June 2025 notification.
Item 2, sir.
What is there? We have been, what has been awarded in a indulgence matter? Sir. This is not a correct reflection. Where is the judgment of the division main page?
Come to page 10.
This one.
ऊपर 9 page, 9 page.
I think.
During the last hearing, I
Says nothing. It was only fixed for the dictation. We could not dictate on that day. Not dictate on that day. You completed your argument.
my lord, during that day, the time was very less, and the last
That's
hearing-
not, sir. This is not a avenue that every time we will go on hearing the matter.
No, my lord.
We permitted you the fullest opportunity. You argued the matter on the other day. It was kept for dictation of the
My
judgment.
lord, the last serial number it was, and the court was.
No, you were heard. It is not that.
My lord, I get the adequate opportunity to to present my contentions.
What you raised the contention, sir. On that day, you argued that I have gone there. I prayed for terminal benefits have not been given to you. It was all belated one. I prayed for interest and compensation. No compensation has been awarded. No interest has been awarded. And then you went to the Supreme Court. The Supreme Court did not interfere with the order, but given you a liberty to go and claim for an interest on a delayed payment.
Yes, my lord.
So what does it connote? We are simply thinking we were going to dictate as it was the last one. So we just said that on the next day we will dictate the judgment. This is the total issue, nothing more than that.
My lord, this is 11 years of culpable delay, and it was intentional, my lord.
What means there is no law, show us a law that unintentional invites a different rate and intentional invites a particular rate. Is there any distinction under the Interest Act?
No, my lord, only.
If it is a delayed payment, whether intentional or unintentional, if you are entitled to interest, you are entitled to interest.
My lord, my humble submission is I have already lost my
And
family.
compensation, I cannot say.
My lord,
And so far as a compassionate, it was not an issue.
my lord, the compassionate employment is still under the process of
So that we never consider. We are not concerned. We are at the very limited stage of. We are granting the interest. There are two ways. If there is a statutory rate of interest, then you'll have to pay the statutory rate of interest. If it is not, since he is a petitioner, so we are saying that prime lending rate fixed by the RBI.
My lord, the interest rate has to be 18%. My lord, it is
You are
Supreme Court has Sir,
We can't go into this aspect.
my lord, the judgments are on the basis of that, my humble submission, my lord.
You cited a judgment, this was under Article 142, we invited your attention. It is not under Article 141.
My lord, the judgments are clearly saying that in case of the culpable delay and the such kind of death and related payments, there has to be a penal interest. So statutory, there
So
actually.
we are giving them penal interest where it is defined a penal interest. Show us.
My lord,
Is there any law? Is there any law which says penal interest will be 30%?
no, my lord, 80% it is
So
mentioned.
that is why if the Supreme Court thought 25% or a 15%, whatever, that is under Article 142. That's a relief which is granted.
My lord,
It's not a law.
my lord, I'm relying upon the case laws which Honorable Supreme Court has passed in past cases. My case is much worse than this because in those cases the petitioners were alive and the employees are alive. In my cases, the employee is dead and 11 years passed.
Question here is not the entitlement. We are in with you that you are entitled to an interest. Now the question is, what should be the rate of interest? The rate of interest varies. There is no straitjacket formula, nor there is any law. Some special statute says this much of an interest. Some statute says this much of an interest. It all varies. There is no uniformity in this. So it is all the discretion which is exercised.
My lord, my humble submission is kindly consider the losses and damages caused. My family, I have lost my family.
Yes,
I don't
that we will consider this. Yes. Unfortunate
Passing the review application subject matter
Is not applicable.
Kindly see the prayer. I mean, see.
No, I am just asking what is pointed out.
This name.
Is not applicable.
No, I'm not. Can you see my prayer in my research matter? I'm thinking the order passed by the honorable single judge in the original writ petition. Thank you, speaking. In fact, in para 1 I have written, so that is how the register. Otherwise, kindly see my prayer.
So why you have written in paragraph 1? If you invite a confusion, then why they should be blamed?
Para 1 I had mentioned, as well as the order dated, the order in passing the review.
So you'll have to, so far as the second part is concerned, you can't, if the order is capable or amenable to be challenged independently, and both are independent order, whether one appeal lies. Sure.
In fact, I can.
Because the word is an appeal lies. If it is in a singular form, can you include several orders into one composite appeal?
In fact, here I am only challenging the original order matter because.
You have said that as well as the order dated such and such.
But that is the conflict. The prayer it is clear. In prayer it is clear. Can you see the prayer? There I have written is to admit this appeal, it's to notice to the resident appeal and allow this appeal by setting aside the judgment dated 31/7/2025 passed
Seen the note appended to the
Item 15.
that's very important for them, may not be important for you.
Cancellation of RC, I think 15 not given copy.
Sorry for this. Item 16. Item number 17.
We don't have to go much in the discussion with you. Please take it over.
Passed to the following binding precedents of the Honorable Apex Court, and those of this very Honorable Court in force of at the time of pronouncement of the impugned judgment been cited during arguments and even before is a patent manifest deep and glaring error apparent on the face of the record, and nothing prevents this Honorable Court to review and recall the impugned order on this sanitary ground. In this regard, the decision of the Honorable Apex Court in Rubanbuji Nahar versus State of Maharashtra at para 134 may kindly be referred to. The citation has already been submitted in the last occasion to this Honorable Court. It is two. Para 107 reading out the High Court.
I have already read out.
Sorry. Your Lordship. There is my kind. Also, a 2024 judgment of Honorable Calcutta High Court in Everest Infra Energy Limited versus Transmission India Engineers and another at page 10, para 23 will be useful in deciding the issue. The Lordship, I'm just reading out. We go with them.
Which judgment is citing?
A judgment which fails to consider a decision which was available at the time of pronouncement.
Mr.
Which judgment you are citing, Calcutta?
Calcutta's.
Where is a judgment?
Now that only, this is another one. Your Lordship, this is.
You have not given it to us.
I'm just right. Just
Yes, please.
let me read out the first.
Okay.
Just 3 lines, Lordship. The judgment which failed to consider a decision which was available at the time of pronouncing the judgment, but was not shown to the court by the same logic is not reviewable on the grounds of being or inferior. But here, in the instead case, Your Lordship, the judgment which that was failed to be considered was available at the time of pronouncement of the judgment, and also it was cited during the argument, Your Lordship. So it attracts the jurisdiction of this court to review. I mean the review jurisdiction. That's wrong. It is humbly submitted that this Honorable Court, relying upon Whirlpool Corporation versus Registrar of Trademarks before and after the judgment, has held that writ is maintainable even when alternative remedy is available, where fundamental rights are infringed. The case at hand satisfies such conditions, and not applying the same to it is a patent error, Lordship. The most fundamental error is the discrimination created by deciding identical cases of orders while relegating the petitioner alone to tribunal errors. The impugned judgment also makes no reference to any citation presented by the petitioner. In State Bank of Patiala versus S.K. Sharma, I'm quoting the proposition of the Honorable Supreme Court, when specific decisions are brought to the notice of the court and the court does not follow them, it is incumbent upon the court to distinguish those decisions or give reasons for not following them. Non-compliance of this proposition is another instance of error apparent, as the judgment assigned no reason why not a single of my citations was considered. The copy of such citations are filed as Annexure 5 series, Your Lordship.
Yes. Yes, good.
Although this honorable court is in agreement with the fact that the amicus curiae is not the substitute of the petitioner, we intend to pass the impugned order after hearing him at length on 2nd, 10th, and 20th of September 2025 on issue of interpretation of section 24B without giving me opportunity for submission of on other crucial issues. Lordship, I respectfully remind that on 20th September, this honorable court gave an impression that it will relegate the matter to the learned single judge with the intent to give more forums to the parties, and the order will be dictated on 25th September in the open court. On 25th of September, though the case was listed, it didn't reach for hearing. It is humbly submitted that by after 24th September, I filed several memos and had interlocutory applications seeking urgent listing of the matter, but none considered, none had, and none disposed. Rather, after more than 2 months, a detailed 22 judgment was delivered dismissing the writ appeal, which came to me as a shocker. This is a clear case of a principle of natural justice striking at the root of fundamental principle of administration of justice and a strong ground analogous to the first category of ground invoking the review jurisdiction of this honorable court. You will see all these grounds are in unison with those laid down by the Honorable Supreme Court in the decisions of the year 2023 and 2013 cited by the Lord AGA. In fact, those citations are in favor of my contentions, and I am in respectful agreement with them. You see, there is no need to advance long-run reasoning to arrive at the inference that the new interpretation of Section 24B will lead to absurd consequences, because all disputes of aided educational institutions involving transfer, retirement benefit, gratuity, etc., will now go to the learned tribunal, which cannot be the intent of the legislature. This information in the judgment is a ground analogous to the error apparent and warrants refute. Even if the new interpretation is held to be correct, it will be prospective, it will have prospective effect, hence not applicable to the present cases. The impugned judgment suffers from multiple errors apparent on the face of the record as detailed. Differential treatment creating Article 14 violation, non-consideration of judicial precedents brought to the notice of this honorable court, ignoring constitutional questions under 14 and 16, overlooking case and service conditions, 23 years of litigation in same issue, procedural irregularity in hearing, misinterpretation of Section 24B, inconsistency with established wrong application of efficacious remedy test. Do not say at the age of 39 when my retirement is
given an opportunity to file an affidavit.
only 8 months.
They must have. The application. Would you like to file an affidavit? Because there are certain things which, according to him, happened in course of the hearing. You have to controvert those factual aspects. You have got the review application with you?
Yes, madam. Review application.
Yes. 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 After hearing the submissions,
Item number 18.
You're appealing. You're appealing.
We have instruction,
Patata.
I have instruction today in morning that
Copy is sir.
copy will withdraw.
Sir, copy on. He's appearing for opposite parties. All the respondents.
CCOD,
All the respondents. Two.
CCOD only.
General Manager Sesu.
Well, same matter. Sesu now has been taken over by TPCOD. So
No,
Same.
this opposite party respondent number 2 notice has to go.
Respondent number 2.
No more in employment. Retired person.
And notice
Chief General Manager. You have made him in person. And opposite party respondent number 1, you can appear.
This is the second round of writ appeal.
Sir,
Earlier writ appeal was filed, that was dismissed and it was relegated to the honorable single bench, and then
What is
again
this?
in the review petition it was dismissed. Now again he has filed it. Before that was in all forums he has lost.
What forum? The
In
the appellate court,
petition
the appellate court remanded the matter for consideration.
for consideration.
So if further consideration is made after remand, then the right is given to him to challenge the said order again in the writ appeal.
But actually, I don't have the details actually, but since 2008 the writ petition was filed. That was dismissed.
So what, after remand, he has a right to the judgment. So why you say that he cannot?
Copy may be.
But there is a problem with him. We will ignore that. Actually, review rejection order is also under challenge, which is barred.
that was under Sesu.
Sesu.
He had been earlier. Tata Power came in
2021 onward.
21.
Tata Power.
No. Whether respondent number 2 was a party to the writ.
Original writ. Respondent number 2. Respondent number 2 was a party. Brindavan Jana. Ex General Manager Sesu.
Oh yes, he was in the writ. Now you serve the copy. Yes. You serve him a copy. Serve him a copy. How? Give him, you have to receive the copy. Tell him that he has to, you have to serve the copy. Writ petition, writ appeal.
He's saying that he will serve a copy in course of the day.
In course of this day, I mean, today. Yes. What is your good name?
Pranay Mohan.
Appears and submits that he has instruction.
Item number 20.
May it please your lordship. The 20, I am on virtual mode, my lord. This is a writ appeal, my lord, arising out of the order of the single judge, my lord. Kindly turn to page 268. The impugned judgment, my lord. The relevant is at 272, paragraph 7, which affects me, my lord. Lordship has paragraph 7. May I please paragraph 7 at page 272?
Just wait, because I have a habit of reading the whole judgment, then do piecemeal.
Please, my lord.
Just wait.
Please, my lord. Judgment starts at 270, my lord.
There is a provision for this training of an ASI. Is
Not
there
the
any provision, any circular?
My lord, that is filed with the counter affidavit of the state government. My lord. Lordship would get that counter affidavit of the state government.
Where
at
is the
page
counter?
263.
Where is the counter affidavit?
It is
My lord, counter affidavit before the learned single judge.
Read of it, page 263.
263.
194.
Eligibility is clause number 3, my lord, at page 264.
No, preliminary counter affidavit.
Of the state government, my lord.
Yes, which paragraph?
Lordship will get page 263. They have annexed the eligibility rules.
263.
263 it starts. The notification dated 15th of October 2020.
That notification is
This is ASI. This is extra.
extra. This annexes and then given gazette notification.
Lordship will see in the middle, my lord, it says this order may be called the Orissa Police Service Method of Recruitment and Conditions of Service of Assistant Sub-Inspectors Order 2020. Eligibility is at clause 3 at page 264.
Where is that notification? Which page?
263, my lord, of the writ appeal.
263.
On your lordship's brief, my lord, I
Okay.
think it will be
Okay, I got
275.
The next page. Clause 3.
Eligibility
That is what is quoted.
Good. So
eligibility is clause 3.
It is
constitutes course of training. You have completed 7 years of
That's right, my lord. That's right, my lord.
completion of course training as on 1st of January.
yes. What is your point?
My lord, my point is, I am a constable recruited in the year 2008. Kindly turn to page 23, which is wherein I have annexed my service book. Page 23 of the writ appeal, I have annexed my service book.
Yes, so
Relevant is at page 25, which demonstrates my entry into government service. Lordship will see right on top,
yes,
date of entry in government service, 25th September 2008.
yes,
And the recruitment details your Lordship will get at page 32 of this very document, Milord. Right at the bottom, it says appointed as constable through regular recruitment. Lordship has page 32.
yes,
Lordship will see, Milord, towards the right column, regular recruitment details. Appointed as constable through regular recruitment with pay band such and such in the scale of pay such and such with effect from 25th September forenoon, etc., etc. Milord.
what, on temporary and officiating basis?
Milord, all constables are appointed as such, Milord, and if your Lordship...
Whatever is
Milord.
there. Why you skip to write or read this?
Milord,
On temporary and
on
officiating
temporary
basis.
and officiating basis. And your
Then-
Lordship, if your Lordship is pleased to scroll back, Milord, to page 26 of the document,
Yes,
Lordship will find, Milord, I am in continuous employment, not page 26, page 27, page 28.
what?
I am in continuous employment, Milord. And there is no entry of any ad hoc in my service records.
No, whatever, but there is no entry of your permanent and regularization.
Milord, the regularization is reflected in the service book itself, Milord.
Hmm.
Otherwise, I could not have continued over such a long period of time, Milord.
No,
The issue is not this, Milord. The issue is
No,
there's
I
no dispute.
understand. I understand. The rule says that the 7 years period has to be counted from the date of the completion of the constable course of training.
Right, Milord. Lordship is right, Milord. There is no dispute on this, Milord.
Yes.
The dispute starts,
And
Milord.
not on the basis of the regularization or something of that kind.
Right, Milord. Lordship will now kindly turn to page 95, Milord. These constables, Milord, after being regularly recruited, were suddenly treated as ad hoc because they were in excess of the reservation percentage. They came before your Lordships, Milord. Your Lordships, Milord, thereafter directed that they should be regularized. That did not happen. And void page it's part of the writ application, Milord.
Then what?
Lordship will get at page 95, order dated 4/2024. It
Yes,
starts
what?
at
At page 104, it starts, I know.
Milord, I am relying at page, Lordship is right, Milord. Lordship takes page 95 for a moment.
Oh, please, which paragraph of the judgment you are relying?
The last three paragraphs, Milord.
Paragraph 44, 45, 46, what?
43, 44 and 45. Lordship kindly takes that for a moment.
Page 145 of this data.
145 of the Lordship gets paragraph 43 on a careful analysis of the impugned orders. Now these petitioners...
Who is for the other side?
Milord, for the state.
Yes.
Now, Milord, now the learned single judge, Milord, despite the direction prior to in 2012 to regularize the petitioners, the state has slept over the matter. This is acknowledged in the counter affidavit. And in the counter affidavit, the state says, I am eligible to go for ASI training, Milord. And your Lordship will get that relevant.
I do not find from that particular clause that there is any age barrier which is kept there. It simply talks about 7 years from the service.
Milord, in my
from the date of completion.
I am obliged.
So now the regularization, if it is made even today or thereafter, then
Milord,
so far as
My
7
respectful-
years counting is concerned, it is from the date of the training. And at page 26 of your service book, your training was imparted in 2009 and 10.
I'm deeply obliged, my lord. And this is the first time the ASI training is taking place after 2015, my lord. My respectful submission is juniors are being sent, and only because the government has not regularized my service, I am being held back from going for ASI training. This is my respectful submission. And in the counter affidavit filed by the state, my lord, they admit this position. Lordship will get that at
What is your
my ranking is also disclosed by the state government, and yet they do not send me, my lord.
where is a condition for the training of the ASI?
My lord, if your lordship takes their counter affidavit, the relevant paragraph.
Sir,
it will
from
be
the
clear.
rule, I just wanted to know that what is the condition precedent eligibility criteria?
It's there at 197 of the counter affidavit.
Please, I do not find that. He has quoted, and then where is the provision?
Kindly come to 197.
Yes?
266 of the rate appeal. Plus 266. That is the rule. There is a trending. Clause 7 is the trending.
That's right.
Page 266.
Yes?
Clause is the trending.
Who can undergo a training of the ASI? I am asking you, sir. Who can go? Why training? You are a constable, sir. You have not been
That's right.
promoted to the post of ASI.
My lord,
There
I
is a
see.
question of undergoing a training of the ASI.
My lord, I have given the qualifying examination. My result is kept in a seal cover. I'm eligible to go for the training. All I seek is consideration to go for the training. Now, kindly see what they say at 197
Why
of the
you have
recipe.
kept the result in abeyance?
That is in pursuance to an order passed by this honorable court moments.
And the matter has been disposed of. I have
This-
annexed that order. Annexed that order at page 74. Kindly see. It is in the batch of writ petitions disposed of. There was an interim order permitting me to appear in the examination. Now that writ has been disposed of from 4/11/2024, you do not open the result. Therefore, you bar me from going in training. Please see page 74 at 77.
Yes.
Now, it's two things. When the writ petition was disposed of, there was no direction to open the seal cover. Reason being, my lord, that this honorable court found that, my lord,
That was an interim order.
Yes, my lord.
Keeping the result in abeyance or in a sealed cover. The writ petition was disposed of. What was the direction passed?
Petition was disposed of, my lord, washing their order of regularization. They were treated as ad hoc employees, my lord, not regular employees. And the matter was remitted back for the state to take a decision on their regularization in terms of certain directions. That has not been implemented. So as of now, with the eye of law, they are not regular employees. And that is the premise on which the honorable single judge is proceeding. If my lords will come back to the interim order, my lords, at paragraph 7 of the...
I have gone through it, but so far as the eligibility criteria, I was just under that impression.
Look, why
It does not talk about, he simply says 7 years from the date of the constable training. And the training you imparted in 2009. So if 7 years have passed, then what?
7 years, my lord, as a regular employee, my lord, as a constable on
Where is the rule which talks about the same?
As a constable, so it has to be understood, my lord, as he has been given appointment on a regular basis, my lord. Otherwise, my lord, if it's on an ad hoc basis, he cannot be considered as a constable, my lord.
So what is the rule? Suppose if he has not been, then when you will regularize him?
My lord, that the process is now, my lord, it is on, my lord. In the direction issued by this honorable court, that process is on, my lord.
What on?
As of now,
Since when it is on? 24?
This
2012. From 2012, it is on.
No, my lord. This order was passed in the year 24.
Not at all.
24,
It refers
my lord.
to judgment of this honorable court in 2012. And kindly see page 200. What they say. I am eligible, yet they don't send me. Please see page 200.
These are the things. File. You come ready. Both of you are directed to file a written notes of argument
My lord.
addressing an issue. Keep this matter after 3 weeks.
Your Lordship may call it next week, my lord. The training is started already. I'll lose my opportunity, my lord, and my seniority. And at page 200, they admit my position in the seniority list.
Seniority taken care of by the.
No, kindly see 200. Kindly see 200 minute. Just 200,
Keep the
one page.
matter after 2 weeks.
Item 21.
Short written notes of argument to be filed by both the parties.
Item 21.
Deeply obliged.
Here, the Lordship would see section 115 of the Orissa Gram Panchayat Act. There is a specific provision. The Lordship sees
Sir, first let us see the impugned order.
in order, my lord, is any
Page.
one,
Page.
page 18. This has been passed.
Just wait.
This IA has been entertained after.
Just wait. I have not finished. What was the IA?
IA was for implementation of the,
So that has been allowed.
that has been allowed.
Who are you?
Now, my lord, I was the opposite party number 5. It was
So this implementation, if there is an order,
my lord.
then what can you avoid?
After disposal of the main case.
What main case?
So may I just submit, my lord, what has
No, sir. Just tell me that IA was filed in a disposed of matter or in a alive matter.
in a disposed of.
When that was disposed of?
The writ petition was disposed of on 18 July 2025.
And when IA was filed?
IA was filed thereafter. Raised out of a disposed
Because that order was affirmed in WA.
affirmed in W.
So
Now, may I just apply what has happened?
So instead of going for a contempt, they have gone for a IA.
My lord, there is no difficulty there. My lord, let's see what has happened.
That
Now,
was
section-
19th December 2025.
Writ appeal order also we have given.
19th December 2025. That IA.
So implementation has been given, and by that order, the petitioner therein was directed to be reinstated. So reinstatement has to be done.
Now the issue is,
A question is whether separate proceeding is to be initiated or in the same proceeding the court can implement. What is the
that is one issue. But that
There's nothing. There are judgments. It says that even under 151 they can.
My lord, I'm not on that. My lord, may see the main question here.
Question will not go. Simple implementation of the direction passed in WP or WA.
My lord, now
That's all.
this would have the impact of rewriting the statute. Because the
Sorry,
statute
then
says
why you did not convince the writ court?
we did, my lord.
I mean, sorry, the writ appeal.
Writ appeal, my lord, may see the order in writ appeal. We have
Affirm the order of the WP.
It affirms. My lord, may see the order. My lord, may kindly see the order in writ appeal, page 73. It is just that it was the finding was that it is premature. That's why the writ appeal court didn't interfere. My lord, may see the
I do not want to go into that. What was the writ court did? Directed the reinstatement?
now, my lords, there are two.
I am asking you, be fair to the court. I have not gone into writ court directed the reinstatement.
That writ court said that you reconsider the issue of the petitioner within a stipulated period. If you don't do it, then reinstate.
Correct. Did you consider it within that time?
No, state was to do it. State was.
They did not.
they haven't done it today.
So if the consequence is also provided, then the
Consequences-
consequence has to follow.
No, that's correct.
Correct. And the order was challenged by whom? State or you before the writ appeal?
Fine.
You. You could not succeed.
I could not succeed. The finding is that it is premature.
Whatever.
But the
be.
period is not over.
Correct. So that is done. Ultimately, writ appeal goes,
My lord.
affirming the order,
Now, my lord, may kindly-
even on a technical ground or on whatever ground. If the court refuses to interfere,
No, my lord, may kindly see the issue here. The issue is if the Sarpanch doesn't conduct a meeting within a specific.
we are not concerned. We are concerned with the reinstatement.
Now, the order also has many errors of record. But the honorable single judge
Sorry.
records that.
Show us that
My lord, may kindly see.
one judgment. Let me understand the law. The order was not without jurisdiction. If it is an error, erroneous order, how far? Can it be reopened after the appellate court affirmed the order?
Now, my lord, that's why I have annexed the appellate court's order. Appellate court.
Maybe on the technical ground, whatever be the reason, it's an affirmation of the judgment.
But there's a specific finding.
No.
That my lord, the said authority has not come up before us, challenging the order, and in this regard,
These are on the locus
appellate
standi of the appellant it was.
No, my lord, the only thing I want to point out, my lord, is this, that there's a specific provision.
Committee and you can't, this is not a second round of litigation where you should.
Because of the latches of the suit.
Please apply your mind here. What will do?
No, my lord, may I just show one thing? Here, my lord, may just see section 115. Because the entire exercise is in the teeth of section 115 of the GPI. May I just take 2 minutes for showing that provision? And the honorable single judge interchangeably records that it's a case of suspension, and in some places it is saying that it is removed. Now, once it is removed because of a statutory embargo, thereafter reinstating him without going into the merits, because the question whether he has conducted 3 meetings or not has not been gone at all. So the merits of the order of the collector have not been discussed ever. Now, this embargo under section 115 comes straight when he doesn't conduct those 3 meetings. Those factual findings have not been upset at all. So now this order and this reinstatement would be in the of section 115 6 minus 8. It says that if you don't conduct meetings, you shall be ordered to be removed, which the collector has done. And that order of the collector is in great detail. It's there. Detailed hearing was done. That's at page 49. So fact remains, factually, he has not conducted those meetings. So in none of the orders, this aspect has been gone in. My lord, I bow down. This technicality stands on the way. My lord, may kindly see that the other question remains that whether you can entertain IA after disposal of the main case.
Can
That
151 can be resorted to.
CPC, man. But insofar as
Same principles we can borrow the principles akin there too. Where is it says, I think the rule also says mutatis mutandis apply. So it's a principles which really applies.
No, the Lordship allows me, I'll give a recent judgment of the Supreme Court where these IAs have been frowned upon, that these IAs are the rule.
They could have gone under the contempt. There is no difficulty. Now they have gone under 150.
Here, we are the persons who are agreed.
Just.
Paragraph 14. You let me kindly see.
Just. Thank you. So may I distinguish this judgment?
Only thing I can say, Madam, he has not conducted those three meetings. That issue has not been dealt with at all.
Is it required?
It is statutorily required.
I'm again saying, when a main writ petition is disposed of, whatever be the findings, and the ultimate conclusion is that you have to complete the hearing within a time frame. If you do not, then you'll have to reinstate. This is really not coming under the purview of this application, miscellaneous application. There, they wanted to reopen on a fresh cause of action. Here is the application seeking implementation of the order. Whether the implementation under 151 can be resorted to in a disposed of matter.
Now, may I just submit? Earlier round minutes I had come, it was premature like
Sir, because it's the same judge who has to hear out the application. It may be categorized as the contempt application, may have been, but it is really in the nature of an execution.
No problem there. That I want to
No,
know
sir.
the statute.
Here, the fact was something different.
Here, my lord, so
Then there are a larger quorum judgment of the earlier Supreme Court.
I'm not, my lord, only thing can I.
Then I have to go by that mandate of law.
Only one point I.
Let us see. No, your point is very clear. Let us see.
Only point is that 3 meetings have not happened.
Can we go into those nitty-gritty after the matter is finally disposed of? Can you reopen? Is it not tantamount to reopening of the issues? We can't do it in this way.
Only thing I want to submit is
No, sir. By the law.
Because of the laxes of the state, the entire Gram Panchayat will suffer.
No, we can't do it anything. You could have raised that issue.
The only place where I can raise it is here. This is a writ appeal. Now, because of the laxes of the state, the petition, the entire Gram Panchayat will suffer. And
what can be? You could have raised that issue when the writ petition was there.
Because the direction was innocuous. You dispose of, otherwise he will be reinstated.
It is not an innocuous because the consequence has been provided.
No. That's
so it does not become so innocuous.
No, my lord. In fact, the Honorable Single Judge in the earlier round didn't agree with the petition. That finding can I show, my lord?
No, we can't.
Earlier round.
Then why it has said so? You could have raised that issue that this could not have been observed.
Now, my lord, may kindly see that finding of the Honorable Single Judge.
No, sir.
Page 66. And the error of record remains. Had it been a case of suspension, things would have been different. It's a question of somebody being removed. So that the order interchangeably.
It's a question of implementation. No, it's a question of implementation. Who is for the other side? What do you have to say about this judgment?
This judgment?
This judgment of the Supreme Court.
Yes, sir. My lord, my lord said exactly the same thing I wanted to submit.
Show us the judgment. Show us the larger quorum judgment.
My lord, I have the copy of the same judgment.
I am asking, show us the larger quorum judgment. It has been held somewhere. That is the difference. Show us the larger quorum that for the purpose of implementation it can be done. Show us the judgment.
In the same judgment only, at page 18, my lord will see that it is written, the nature of the IA that is in this case is for a stay order or seeking protection. I am only seeking for whatever already is part.
I am asking you, show me a judgment that there is no fetter on the part of the court to pass an order implementing its own order in a disposed of matter by way of an IA. Show us. Why the court will find out this the judgment for you. This judgment is distinguishable, sir. This judgment says that once the proceeding is disposed of, the court becomes functus officio. Only a limited jurisdiction it has. Correction of a arithmetical, ministerial, or something of these errors, or modification in a very rare cases. But apart from that, one more review jurisdiction can be invoked. But that is what it says, that IA, whether for implementation, it's really an execution of an order. Then you'll have to bring those line of judgments. He's citing, you should be ready with that.
My humble submission is at paragraph 18 of the same judgment only. The answer is there.
Answer is there.
Yes.
So then we will follow this without going into.
I'll just try to read.
Yes, please. I have seen.
The registry shall not circulate any miscellaneous application filed in a disposed of proceeding unless and until there is a specific averment on oath that the filing of the miscellaneous application has been necessitated as the order passed in the main proceedings being executory in nature. Then and have become impossible to be implemented because of.
So this is what impossibility of the execution.
In my case, I
am asking. This is what that shows that if there is an impossibility to execute the order, then you can make an application inviting the attention of the court. You are not understanding what is playing. You do not know how to deal with this judgment. Sufficient indication has already been given, but you do not understand what is done. Then we'll go by this.
We'll
go by this. If this is an answer, we'll say it's not a complete answer. We do not find.
Able to understand because. But what I have tried to.
Then who is to be blamed? The bench or?
My lord, the judgment. I have only. And I will research on this.
So what we were saying to you?
I have a small submission also. The rate appeal. In the rate appeal, my lord. In the rate appeal, my lord, has specifically in the last paragraph has total. I'm talking about the locus.
You are not following what comes from the bench, and senior counsel is advising.
I'll try to find out some documents and put.
No need to argue. We'll dispose of the matter.
My lord, I will get.
No need to argue.
I'll get some documents.
Next Monday, keep it.
Item number 22.
Same order as well as reinstated. There's nothing.
Let it be.
Next Monday till 1 week.
No, let it be.
Because this, in some, I'll also get those judgments, including the old one. Some say that this may not be without, this say that it's without. But that 151 principle, I bow down to that. And why I'm pressing for this is this. Because he has actually.
No, sir, it is, or it could have been under order 21, rule 32.
I bow down to that. 151 and
no, sir. Execution can also be done. Anyhow, what
let there be status quo as on date.
Find out their age. So you are for the, who are you, sir?
I am for the writ petitions,
Sir, I think,
writ petitioner in this case.
sir, the relief has been granted to you.
There is only the fact which your lordship kindly imagine. I have been saying to the person.
No, it says that, and the correctly says that so far as the reversion order is concerned, once you have been promoted, a right has accrued into you have to be heard before you are put back to the original position at the feeder.
That's right.
This is what the court has said.
Then the opposite party number 7 is to pass a fresh order. Opposite party number 7 filed the counter appeal. He is not
Admitted that there was a violation of principle of natural justice in the counter.
the opposite party number 7 defended the order of reversal because this under court. And the opposite party number 7 was also not my appointing authority. So it would be a Caesar to Caesar.
Caesar's wife, not Caesar to Caesar. Caesar to Caesar's wife.
Again, my lordship,
What? Encroachment?
encroachment to a public road and an appeal proceeding has been evicted, but honorable single judge has, while passing the order, lordship has restored back the position to the person encroachers to a public road.
Let the state has also filed a writ appeal. I'm looking the number, maybe track out.
Yes.
Road is earmarked. Road is earmarked or people are using?
No, lordship. Road is there, that's it. Because there is some procedure eligibility. And not single is a point order and it's restored the position to the unauthorized position of the public road.
No, he was occupying the public
That
road.
has been demolished, lordship.
Correct.
That
So
has been
all his structures have gone. It has now been converted into a
Public
road,
road.
metallic road.
Yes, lord, yes.
Issue notice to the writ petitioner. What is the date of the order?
24/12/25, lordship. December 26.
Not likely to be. Contempt has not been filed.
No.
Yes, notice 2 weeks come.
Also, cannot status quo, lordship. Road is
That- Why I asked this question
there. Lordship.
was reason for interim order.
That-
Yes. With this. The government has also filed an appeal. State of Orissa.
Writ appeal or notice,
Item 24.
including IU.
Please, Your Lordship. Your Lordship, I appear for the respondent.
Let's go with that.
Yes.
Was the arbitration proceeding, the interpreting the terms of the contract that it's been what's contractual applicable hardly.
Oh, yes.
Yes. Your Lordship, on the last date of hearing, Your Lordship had, the other side had cited the judgment in Bhavin Construction to argue that a writ will not be maintainable against the Section 16 order. Your Lordship, I wish to make only 2 points. One, judgment of the Honorable Supreme Court, Your Lordship. My learned friend will just hand over that judgment in Tamil Nadu Cement as to the maintainability of a writ, particularly in an MSME arbitration.
That is a different. Sir, entertainability is the most important hallmark because the maintainability is one and entertainability is another. I think in some flat, we have held that it is not entertainable.
No, Your Lordship, in fact, even in Sunflag, Your Lordship has carved out an exception for inherent lack of jurisdiction. Today, Your Lordship, my case is there is inherent lack of jurisdiction. If I don't fall in that bracket, then Your Lordship is right that there is no jurisdiction for a writ petition. This judgment, Your Lordship, of the Supreme Court, this issue has been in fact referred to a larger bench of 5 judges. And specifically on the issue of maintainability of writ in MSME matters. Because MSME matters, the proceedings are slightly different. The procedure is slightly different, unlike normal arbitrations.
No, that is true. Again, in India Glycol,
yes,
it says that intertenability does not really bar the petition. Bar cannot be done.
Your Lordship is
It
right.
can
Which
be
is why,
done.
Your Lordship,
Anybody can come, but only thing is when
No, Your
and
Lordship-
under what circumstances the court should interfere.
Your Lordship is right, which is why, Your Lordship, the limited exception is inherent lack of
No,
jurisdiction.
Section,
And Your Lordship-
section 16, the arbitrator has ruled his own jurisdiction, and by virtue of SBP Limited judgment of a 5-judge bench in 2008, I believe,
Yes.
you can challenge it at the along with the award.
Your Lordship is right, but Your Lordship may just bear with me 3 paragraphs of Tamil Nadu Cement. Your Lordship may just have paragraph 50 of this
Yes.
judgment, 49,
Yes.
50.
Yes.
And this is where the exception is in cases of MSME, Your Lordship. Paragraph 49, I'll read. In our opinion, there is a direct confrontation between the judgment of 2 judges in Jharkhand Urja and Gujarat State Supplies. We also have reservations on the dictum of India Glycols, and Your Lordship, this is a 3-judge bench, which holds that a writ petition is not maintainable against any order passed by MSME, and the only recourse available is in terms of Section 34 of the Arbitration Act, and that too would require a deposit in terms of Section 19 of the Arbitration Conciliation Act. This is a case of statutory arbitration that is mandatory. It is possible to argue that it bars a party from moving the court of law under Section 9 of the CPC. Section 18 also overrides the principle of party autonomy when they enter into an arbitration agreement which prescribes the procedure for appointment of an arbitrator and conduct of arbitral proceedings. The statute further prescribes an undoubtedly high rate of interest, 3 times that of RBI, presently 6.5%. The interest is compounded with monthly rest. Lastly, an order or an award can be challenged by the buyer only on deposit of 75% of the awarded amount, thereby restricting the right to challenge the order/award passed except on compliance of stringent conditions which are not prescribed when an appeal is preferred under the CPC. Pre-deposit is a condition for hearing a decision on the objections to the award. The issue therefore arises and needs consideration is whether there would be an absolute and complete bar to invoke writ jurisdiction under Article 226, even in exceptional rare cases where fairness, equity, and justice may warrant the exercise of writ jurisdiction. I'll skip one paragraph, Your Lordship. Then Your Lordship may straight away come to paragraph 59. In paragraph 59, Your Lordship, they refer to a judgment of the Constitution Bench. It is in this context that a Constitution Bench of 5 judges way back in 1954 had observed that the principle that the High Court should not issue a prerogative writ when an alternate remedy is available may not apply when the remedy under the statute is onerous and burdensome in character, such as when the party has to deposit the whole amount of the tax, filing an appeal. An alternative remedy must be equally efficacious and adequate. So, Your Lordship, which is why, and then Your Lordship, they refer the matter to 5 judges at paragraph 64. Your Lordship, my submission is that, Your Lordship, there is no alternate efficacious remedy. If I was to challenge that award in a Section 34, I have to deposit 75% of the amount. And there is no party autonomy in appointment of an arbitrator in this case. And Your Lordship, in fact, that is also the point of distinction in Bhavin construction. In Bhavin construction, Your Lordship, what had happened was the arbitration was invoked as per the contractual procedure. The opposite party had...
There are 2 aspects of the matter.
Yes.
Now when you are arguing, then you open a larger Pandora box. First thing is, even if we proceed that the writ petition is maintainable, then if there is already a condition which has been imposed for the purpose of her appeal, is it not based on an equitable principles? And the court in some of the cases has to consider it. And when it comes under the MSME, and if they come under the MSME Act, are you registered under the MSME? So then in that event, why and under what circumstances the challenge is to be done?
Your
So
Lordship
come
is right.
ready on both maintainability or merit also we will consider.
Very well, Your Lordship.
Okay, when you are ready, both on merit as well. If we hold yes maintainable, then also we enter into the merit and dispose of.
Very well, Your Lordship.
When
Your Lordship may have
is only on Mondays.
Yes.
Mondays, Your Lordship. Your Lordship may have it on 13th. 13th of April, Your Lordship, if that is convenient with
you. Come on to 13th.
Very well.
Come ready on merit also.
Very well, Your Lordship. Deeply obliged.
On the last day, Your Lordship heard it on merit whether the Honorable Chief Judge holding it to be works contract by interpreting the terms of the contract is it possible?
Works contract, let us see how far. I think after 42nd Amendment in the Constitution or 44th Amendment, work contract.
Article 363.
Yes, when it is amended by 42nd or 44th.
64th, that one. 42nd, Amendment, 1982. 29A, clause 29A. Article 366.
Yes. Item 25.
Your Lordship, in item 24, I'll be coming physically. Your Lordship, may I only make a small request if the matter can be taken up higher on board, just in case.
Come.
Sure.
Yes.
If I might also, like, a short accommodation. Actually, I met with an accident recently where in the bus. It is. My love? No, my love.
Item number 26.
My love, any day after 4.
6th.
I'm giving you.
26.
And there is delay of 200 days.
Service.
Item 27.
Same services.
So there is a delay of 5.5.
Service 3 weeks.
Similar matter has already been decided by the coordinate bench. Item 27.
Yes.
Sir, there is a delay. Delay has to be, you are conceding for a delay?
No, in that case, my lord, there-
You go there, first you file 500 and something days delay.
yes. Item 28.
Yes, name that we appear and make service of notice of appeal. So now the state is directly to serve the.
On the ground of delay as well as on merit.
Both. You are appearing in a tag matter
Yes, of course.
also?
Yes. 28.
This is matter regarding selection of.
Sir, copy.
Yes, sir.
Yes, but private opposite party is there and
They have to be served.
That's why I will solve a copy.
Sir, 3 weeks.
Nobody is appeared. The petition that.
No, you'll have to affect the service. Condemnation accrued a right in them.
Yes, I will solve.
They have to be done.
I will solve.
It's
29.
service.
yes,
Yes?
this is a delay of 214.
I think, sir. Service. You are appearing for whom?
We are instructed to appeal to the respondents. There
That's
are two heat appeals.
whatever I indicate. Base service of notice. Undertake to file Wakaratama within. Wakaratama, you have to file
Within 2 days.
yes, within a week.
But I may be.
Better to appear after 2 weeks. Yes.
My lords, there are two heat appeals of the same judgment. So there may be.
Don't worry.
I'm appearing in the appeal which has been mentioned today in the board. I have already filed Wakaratama. It's civil.
Slip over.
Was the same judgment, it was two writ appeals.
Yes. Three heat appeals, one.
Another one has to come.
Can-
This separately with the 30.
Item 30.
Delay is 27 days now.
I am the respondent number one.
This is a single respondent, sir.
2, 3, 4 is the
You
government.
are,
I am for the one.
2, 3, 4 is for the government.
there is no another or others, that's why I am getting confused. To cause this. I see.
Item
And the lady submit. There are 4 respondents,
Why is there not?
so
but 2, 3, 4.
Yeah, one minute, sir. You are appealing for.
None of them. Respondent number one. Respondent number one.
Wow. And
Two, 3, 4 is the government.
are you appealing?
Yes, ma'am.
Copy, sir.
Yes, ma'am.
No, not. Sir.
Then.
I'll solve within one.
Yes, for the opposite party. Sir.
I'll solve within 1 week.
Yes, sir, in course of this week.
Yes.
Next week.
item 31.
1 week afternoon. Next week I have some problem.
Oh.
Sixth one.
August 1 week.
Sixth one. Sixth appeals. Item number 31.
In this matter, the delay of 500 years.
Have you, sir? No. That is.
It's 32. Right. Item 32.
32 minutes, 303 days delay. I'm appealing for the respondent. Copy page sub folders.
Yes, all names.
Item 33.
In item 33, I am appearing for the contesting respondent.
Again,
The
copy has
copy
been
of the
served.
appeal memo and the limitation has not been solved.
I'll serve
Please serve me no copy.
by tomorrow.
Yes, by tomorrow. 2 weeks. Next.
Item 34.
The before service.
34.
Task. Notice, pending
Notice of
I am accustomed to the word service.
service has to be.
Anyhow, yes, notice.
Well,
Notice.
got it.
Next.
Item 35.
The first ballot pursuant to direction of minors that sought copy to my sister. With the delay of first one, then the delay of 89 days.
Who is appearing?
My sister.
Did you?
89
94
days.
days.
The first one is 89 days, other two are 94.
Yes. Would you like to oppose?
Yes, ma'am. Yes, ma'am.
What?
But because in the first para, only the executive that the office process to file to take further course of action, that is the only ground they have mentioned. For that reason, in one it's 89 days, another 94 days.
It is insufficient explanation according to this one. Where is the application?
You can see number 207. First problem.
What is the date of the judgment?
Date of the judgment, madam. 23rd of September 2025.
Nine 20.
79-20, page 19. 79 2025.
What is the date?
17/9/2025.
And when you apply?
26 minutes we applied.
23rd.
26. No, something. It is we applied when I was 22.
What petitions are being drafted? Look at your paragraph, you are saying.
I bought on much. This is not sufficient advance.
Then what happened thereafter?
Thereafter, in fact, I found from the record matters, the file was processed. And so as to take a decision whether to prepare appeal or not. Then in the process, legal opinion was obtained.
When you approved the counsel for legal opinion?
The detailed dates matters, adopted matters, the minus record matters, I will get it through it. So far record is concerned, I can find it for my affidavit detail.
Judgment, but inadvertently I cannot brought to days. Which shows that yes, yes, my lord, but I forgot to my lord. My lord, he says office process, that administrative, that office process the file is not the sufficient reason to condone the delay. That I'll cite, my lord. Next, on the next. Yes, my lord. Yes, on all three matters.
Item 36.
I'm appearing for the sole respondent. My pair usually also let their delay may be condoned, let it come on fresh admission.
How many days delay?
It must be 300 days more, my lord.
You are accepting?
Because I want that your lordship to impose cost on every case they are having writ appeal. The department is coming. 149 days. 149. In each and every case, my lord, of honorable single judge, they are filing writ appeal.
If this matter for the fresh admission next week?
Yes, sir.
My lord.
Yes.
My copy may be solved.
Yes. Copy is immediately in course of this week.
And next
then keeping this matter after 2 weeks, then service in course of this week.
My lordship always says after second contempt, they will file it later. First and second.
Yes, for the next.
Item 37.
Madam, same, the regulation.
146 days.
Who is appearing?
Madam, I am not.
You are appearing for 7 also? Yes. Same order? 2 weeks. Yes.
Item 38.
Confirmation?
88, my lords, notice was sent, but the noting is,
The noting says the thing.
Non-short.
but my learned sister appears for the sole
Have
respondent.
you received the copy?
No.
I had served copies, but somewhere misplaced and served copies.
After 4 days.
Item 39.
Copy.
Item 39.
Take the service. The 39 notice has to go to opposite party number 4 to 39 who is appearing.
It's.
Go to the service. You have received the copy.
I have received.
Go to the. Leave this notice by this week or 3 weeks. 4 weeks, sir. Yes, next.
Item 40.
Delay of 161 days.
I've already received, my lord. The similar matter, my lord.
Oh, have you got the copy of the termination?
Yes, I have got.
What we say, you want to file the opposition or you want to ask for the.
Similar matter, they have filed an SLP. SLP is already dismissed.
Where is the donation?
Yes, my lord, 160 days delay.
That is dismissed.
No, my lord, merit dismissal. Similar matter.
So are you considering for condonation?
Yes, my lord.
Concede. So record the concession. We have to be very clear. You have to be very clear. Later on, you will not come and say that there was no concession.
In that case,
Yes, my lord.
it appeals versus dispute on in the annulment application or on merit.
Merit.
On merit. So that the SLP against that order was dismissed.
Dismissed. Similar matter.
Condonation orders. Conceding.
Are you considering for that?
No.
And then,
Delay, you are considering or not?
No.
then file objection.
File objection.
Yes.
2 weeks.
Ma'am.
Okay. For the rejoinder of 3 weeks. 4 weeks. Then.
Item 41.
Pardon, my lord. Sorry, pardon. Item 39, my lord, for the petition on matter.
Yes, your applications will be.
Ma'am.
Your appearance will be recorded. We have already
Fine,
done it.
yes, fine.
Yes.
Item 41.
You have made a delay of infunded right.
Whatever. We have to affect the service. If notice for its dates.
Item 42. Yes, ma'am. Item delivered.
No, but there is no appellant. I do for 3 weeks. That appears.
Item.
That's why she-
3 weeks. Ma'am. Item 43.
Second 43 is the date, 42 days. 42 days is the date of delay.
So you start the copy, are you appearing for all?
The notice has to go to OP2, Millets.
OP2 is also developed. So it is concerned and everything.
Whatever a right has accrued by virtue of no lapses, it must be notified. This.
Item 44.
Step to evict us from the intent.
Okay.
There will be a
Weeks, come.
Item 44.
Item 44, my lords, I am appearing for the caveator, my lords. Let the 44 and
104 days delay, officer.
Sir, copy.
Copy and serve, my lords.
No. What? Caveator, he says. Copy, sir.
Copy has not been served, your lordship.
Just imagine. Who will?
See, sir, serve a copy. You must be having extra copy. Why don't you serve it?
Don't have it. I will serve.
Yes.
Next service. Record the name and service. 2 weeks.
Item 45.
May I pray one thing, my lords? May I pray one thing? Let the delay be conducted, let the matter be taken up on fresh admission case, my lords.
Which one?
Item
44.
44 and 45. Let the delay be condoned, my lords.
So record the concession, delay condone. So after 2 weeks for admission.
45 also are you appearing?
44 and 45. My lords, although I appear for caveator, but my name inadvertently my name has not been reflected, your lordships.
45 record karo.
Next 46.
Just to reflect his name.
Item 46.
I am for the appellate.
180 days. Yes. Have you served the copy on all? All?
Yes.
What do you say?
I leave it, my lords. Whatever.
What leave it? It can't be a leave it.
There is a delay 180 days. My lords may pass office.
What is the ground?
Proceeding initiated against the appellant.
Why you did not file an appeal within time?
Due to misplaced of the file due to renovation was.
What?
Misplaced of the file.
What misplaced of the file?
The tamper due to renovation of the work. Going on public department. He requests the south and I file it.
After retirement, there should not be continuation of proceeding.
This is the application for donation of delay in preferring the Who is appearing in 48?
I connected.
Next speaker. You are